Mr. Lewison.
So the key amendments proposed by this bill make our roads safer by deterring dangerous and risky behaviours on the road through heavier and broader criminal and administrative penalties. I stand in support of the general rationale behind the amendments, but would like to seek clarifications on two areas relating to the obligation of drivers in accidents involving animals and the legal effect of compounded offences under the RTA. So for more than 6 years, I've been campaigning to amend the definition of animals in the Road Traffic Act. The campaign started before I was elected as a Member of Parliament and continued when I became an MP. I raised this issue in this House in 2016, and then SMS Desmond Lee replied that the definition of animals in the RTA will be reviewed. I'm delighted that we're now proposing amendments to this. The current definition no longer makes sense. Animal means any horse, cattle, ass, mule, sheep, pig, goat or dog. Under the RTA, motorists are required to stop and help these animals if they are knocked down. I understand that, quote, the original intent of the legislation was to ensure restitution to their owners should an accident occur, unquote. But the days of having horses, cattle, asses, mules, sheep, pigs, goats on our roads are long gone. As such, our legislation needs to be updated to keep up with times. The unfortunate reality is that we now have other animals on our road, a lot of them. It is a long list of animals including cats, civets, pangolins, wild boars, monkeys and snakes. The other unfortunate reality is that these animals are often knocked down. At times they are not killed and could recover if help is provided. As Minister had previously stated, quote, the question is whether we should now mandatorily require all motorists to stop should they hit an animal. The primary requirement must be safety. They should stop if it's safe to do so. If the motorist requires assistance in relation to attending to the animal, he can contact the Agri-Food and Veterinary Authority of Singapore, or AVA, or the SPCA, unquote. They can also call ACRES. The bill proposes to remove the definition of animal under Section 84(6). This creates a catch-all provision in relation to a driver's obligation to stop in the event of an accident involving an animal. This is in line with what animal welfare groups have called for, but I have some concerns about this amendment and would like to seek some clarification. The effect of the current amendment is that a driver who runs into any animal may have an obligation to stop regardless of the species of the animals. An animal could be anything from a dog to a lizard. Taken to the extreme, this provision could have ridiculous implications. I agreed that we need to expand the definition of animals beyond the current definition, but I also appreciate the difficulty of coming up with a definition to limit the scope of this provision. However, removing the definition altogether seems to be a blunt measure. It simply shifts the burden of making this difficult judgment to the driver. We are asking a driver driving a fast-moving vehicle to make an instantaneous judgment on whether an animal is likely to have an owner, or whether the injured or dead animal will pose a safety hazard to other road users. Is it really safer to require a driver to divert attention away from the road to making this judgment call? Would there be a loophole in that a driver can just say that it was not safe to stop, so he or she didn't stop? To provide some guidance for drivers, can the Minister or SPS provide more clarification on how a driver can determine if an animal is likely to pose a safety hazard and how he intends to enforce this provision? How will the traffic police determine if it was safe for a driver to stop and render assistance? Would it be better to amend the definition of animals to include more animals rather than remove the definition altogether? Next, the new Section 139AA comes in the wake of the High Court decision in Public Prosecutor versus Koh Tiam Huat. In that case, the court decided that it may take into account compounded offences under the RTA for the purpose of sentencing, as they form part of the offender's bad driving record. The new Section 139AA affirms and gives statutory force to this High Court decision. This may raise some concerns because of the prevailing legal principle that compounding an offence amounts to an acquittal in law. This is expressly stated in Section 241 and 242 of the Criminal Procedure Code, CPC, for penal code offences. This rule equally applies to non-penal code offences as held in the High Court decision of Raja Manikam Ramachandran versus Chan Teck Yuan. In May 2015, during the second reading speech for the Parliamentary Elections Amendment Bill, then Minister for Home Affairs, Mr. Wong Kang Seng, explained that the legal effect of composition is that, quote, the alleged offender is taken not to have been convicted of the offence, unquote. Can the Minister confirm that the new Section 139AA will not have the effect of changing the existing legal position, that compounding an offence, whether under the RTA, the Penal Code or other statutes, amounts to an acquittal? Allowing a compounded offence to be taken into consideration for sentencing removes another distinction between an acquittal and a conviction that may be perceived as an erosion of the presumption of innocence. Minister K. Shanmugam said in an oral answer to a PQ in August 2008, quote, the presumption of innocence is an important and fundamental principle and is one of the foundations of our criminal justice system. The government is absolutely committed to upholding the presumption of innocence as a core principle in our commitment to the rule of law, unquote. Can the Minister clarify whether the remaining practical differences are between a composition and a conviction under the RTA? Further, can the Minister clarify if the new Section 139AA is intended to be a statement of the general legal principle of composition beyond the RTA? In other words, is it the case that compoundable offences, whether under the RTA or other statutes, can be taken into account for the purpose of sentencing? Finally, when making an offer on composition in a notice of traffic offence, will the traffic police inform the individual that compounded offences may nonetheless be taken into consideration for sentencing in future offences? The judges in the cases of Ri Lim Chor Pi noted that, quote, there are multiple reasons why a person may wish to compound an offence, whether it may be an income tax offence or offence compoundable under the Penal Code without any admission of guilt, unquote. Hypothetically, an individual who has been charged but had not in fact committed the offence may agree to pay the composition fee to dispose of the matter out of expediency. They may do so in believing that there will be no adverse impact if composition amounts to acquittal. The decision may change if they are now told that the compounded offence remains on record and may affect sentencing in future offences. So these clarifications notwithstanding, I stand in support of this bill. I would also like to thank MHA for responding positively to the concerns raised by the animal welfare groups. Thank you.